Today, BRR speaks with Doug Jones, who's a partner and the head of international arbitration at Clayton Utz. Joining him is Essam Al-Tamimi, who's a senior partner and head of arbitration at Al-Tamimi & Co. Gentlemen, thank you so much for joining me today.
Thank you.
Doug, in an increasingly globalised economy, more and more companies are turning to international arbitration to resolve their commercial disputes. How important is recognition of various cultures and laws to both the acceptance and enforceability of commercial arbitration decisions?
Decisions need to be decided according to the appropriate law, whether that's local or not, depends on the agreement. So far as culture is concerned, it's legally irrelevant, but very important from a practical point of view. Parties need to have their culture respected in order to accept the outcome of decisions, as do local courts enforcing outcomes. They need to appreciate that their culture has also been respected.
And Essam, in your experience with international arbitration and Sharia law, is there a place for Sharia law in international arbitration decisions?
Indeed, Islamic law recognizes arbitration from day one of the Islam, and maybe even before then, but has been progressed through Islam. It's been recognized and developed for some of the Islamic jurisprudence. There is no conflict between Islam and arbitration, and actually they complement each other, and Islamic laws support arbitration recognized. There has been, however, some misconceptions from some of the Islamic scholars and maybe some of the international user that the Islamic law may conflict to the international arbitration and put some restrictions, which is not true. Both of them actually could cohere and work together very well.
And Essam, how might we see Sharia law applied to international arbitration in the future?
Islamic law is a principle of law that's been embodied into codified law in most of Arabia and the Islamic countries. You may find the source of the law that comes from the Sharia and the Islamic principle, but most of the Islamic countries and the Arab countries, with maybe exception of one state, has enacted laws within their codified law, and the principle of it named Sharia. Those laws and regulations that embodied in these local laws does not conflict with arbitration and actually support arbitration, and they could be used in any local or international arbitration, whether in the sense of procedural law or law of substance.
Gentlemen, it's been a pleasure. Thank you for joining me today.
A pleasure.